Good morning. Good morning.
Good morning.
My name is Paul Grogan. I'm the president of the Boston Foundation, and it is my pleasure to welcome you here today for this forum on criminal offender record information, or CORI, which has aroused great interest, as we can see from how full this room is today. Many of you are not here for the first time, I'm pleased to say, but as you know, the Boston Foundation is Greater Boston's community foundation. We're celebrating our 90th birthday this year. We're one of the oldest and are one of the largest community foundations in America, with $675 million of assets. The foundation and its donors made about $50 million of grants to Boston area nonprofit organizations in the last year. But in addition to making grants, another very important role the foundation plays is to host gatherings like this, to sponsor research, host forums and seminars that explore the most pressing challenges and issues facing the city, the region, and the state. Several years ago, we formed what we call the Community Safety Initiative, which was an umbrella multi-year commitment of $1.5 million, much of which goes to nonprofit organizations, some to the police department, but also money goes to sponsoring forums like this one. And this is actually the fifth of a series of forums. The others were on quality of life in our neighborhoods, which was held in Grove Hall, offender reentry, high-risk girls, and CHINs. So this is actually the fifth such forum. And we hope to obviously illuminate complex and difficult issues and spark action. We have a number of elected officials with us today, and more will be joining us as we go along, but let me introduce a couple right now. I know we have Representative Byron Rushing here. Byron, where are you? Okay, Byron. We have Sheriff Andrea Cabral. Sheriff, there she is. City Councilor Chuck Turner. And others will be joining us, and we'll introduce them when they come. But it is now my great pleasure to kick this off to introduce the Lieutenant Governor of the Commonwealth, Carrie Healy. Carrie Healy was, of course, elected with Governor Romney in 2002 and serves as a key policy advisor on the governor's leadership team. She has taken on a broad range of assignments to advance the Romney administration's reform agenda. She's the primary contact for municipal leaders across the state regarding local finance and budget issues, and she co-chairs the Commonwealth's 5 regional competitiveness councils, which are responsible for regional economic development initiatives. She currently chairs several special commissions by the governor focused on criminal justice reform, sexual and domestic violence, homelessness, and the maritime economy. She also presides over the Governor's Council, the body responsible for confirming gubernatorial judicial appointments. But she has a special interest in all issues relating to the law and public safety. In fact, from 1987 to 1997, Lieutenant Governor Healy enjoyed a distinguished career as a law and public safety consultant at Apt Associates in Cambridge, Massachusetts. While at Apt, she conducted extensive research for the U.S. Department of Justice related to child abuse and neglect, domestic violence, gang violence, victim and witness protection, intimidation, and the prosecution of drug crimes. She is the author of 4 books and numerous articles focused on improving standards and practices throughout the criminal justice system. And I'm happy to say that this is one of many times that the Lieutenant Governor has been at the Foundation participating in our forums and programs. Welcome, Lieutenant Governor Healy.
Thank you, Paul. It is genuinely always a pleasure to be here. The Boston Foundation engages in some of the most important and relevant conversations that go on in our state, and they are never shy about jumping in foot first, or head first in some cases, into topics that other people would rather avoid. And so this is an extremely important thing to be talking about today. I am taking particular interest in this topic, and I will want to read the transcript of the discussions here today. I can't stay for them all, but I will, in fact, read this all because, not just because I'm interested in criminal justice, but for 2 reasons. First, because I actually served on the CORI board for several years, and so I've seen up close how difficult some of these decisions can be about balancing the privacy rights of the offenders versus the public interest in knowing, and what we need to do to protect the public, and what kind of sacrifices we need to make in order to protect the public. So I've been up close and personal with some of these issues. Barry and I had the honor of working together, and it is one of the most difficult decisions, I think, that you see in public government, trying to figure out where do privacy rights end and where does the public interest begin. And even beyond that, as someone who has been a huge advocate for reentry, for trying to stimulate this idea that we no longer can simply be dumping offenders back into society and hoping for the best, that we need to take an active interest in making sure that the 20,000 men and women who are leaving our jails and prisons each year have jobs and have housing and have access to substance abuse treatment if that's what they need. These are things that I have been extremely involved with and extremely dedicated to, and one of the concerns around that is the impact of CORI on offenders' ability to get housing and employment, these key legs of the stool, if you will, to post-release success. So I will be interested to hear today how the people in this audience think that the interests of society can be served in terms of protecting the society from dangerous offenders, from violent offenders, and from sex offenders. Those are the key people who I am concerned about public safety when they're coming back into society, while at the same time promoting the successful reentry of nonviolent offenders into society in the most humane way possible. So I am very interested in this discussion. I think some of the recommendations from the white paper were exactly on point. Certainly clarity and accuracy have to be goals for any reform around CORI information. We want to make sure that people who receive CORI information can understand that information as easily as possible, interpret it properly, and certainly that the information given to employers and potential housers and so forth, and certainly the criminal justice system, is accurate. So these are difficult topics. Some of them are just mechanical. Clarity, accuracy, these are bureaucratic goals that can be accomplished easily within our administration by simply focusing on high quality and good management within the system. I don't see that as a problem. The tough questions are, how far are we going to go toward taking risks with public housing, taking risks in employment situations in order to successfully reintegrate those offenders who deserve a second chance. So I wish you a lot of luck in your discussions today. I am very interested in the outcome, and I want to thank again the Boston Foundation for wading into this difficult topic. Thank you so much.
Thank you very much, Lieutenant Governor. I think you have very ably set the table for us in terms of the complexity of this issue and the need to balance competing interests in society. And of course, this issue, which has been slightly below the radar screen, I think, for many of us until recently, joins so many issues that the Boston Foundation cares about. Obviously, safety, but also economic opportunity, housing, the health of our neighborhoods. And so this is where you pull on the string of CORI, it gets very, very complicated. But we are going to, I believe, surface some very good ideas today about where to go next. And to help us do that, it's now my pleasure to introduce Elise Clausen, who was the Executive Director of the Crime and Justice Institute, which has been our great partner throughout the Community Safety Initiative. And before we can take action, we've really got to understand the issue. And I think you are going to see very shortly that the Crime and Justice Institute has delved deeply into the CORI issue and is going to lay some very interesting facts on the table. Elise brings over 30 years of experience and a substantial background in criminal justice, substance abuse, and mental health treatment and education. She's worked extensively with elected officials and other policymakers as both a national consultant and a department director. Prior to heading the CJI, she was the director of the Department of Community Justice in Multnomah County, Oregon, and oversaw both juvenile and adult community corrections for 6 years. Additionally, she served as the assistant director of the Oregon State Department of Corrections for Community Corrections. Elise Clausen.
Thank you very much, Paul. As always, we have really enjoyed our partnership with the Boston Foundation. It's a terrific group of people to work with, and we are pleased that they are willing to take on such difficult issues. And I also would agree that the Lieutenant Governor really did lay out the issues and the competing interests that this whole discussion around CORI presents for all of us. I also would like to acknowledge that I realize many of you in this room know a lot more about CORI than I do. I don't profess to be an expert here, but I am going to try to walk through it, and for those of you who know more or less, give you some idea of what some of the complexities are. I also want to acknowledge that there are a number of people, both on the panel and in the audience, who have made improvements in CORI and who continue to work on the CORI system. So we are not alone in our process. To get ready for this forum, we've met with many stakeholder groups and individuals. It's included advocacy groups, community agencies, government agencies, policymakers, business, and people who have CORI records. We've also tried to understand and verify the problems and issues that have come up as we have talked to those groups and individuals, as well as understand and acknowledge the really valuable part of CORI and the things that work well. The objective really today is to examine some key questions and issues surrounding CORI, and that was really part of our process over the last 2 months as we conducted research and talked to individuals and groups. We also tried to identify common interests among these diverse stakeholder groups and stimulate some discussion and reform, particularly in areas where there seems to be some agreement on things that could be done. Just to give you some context, in the United States, 59 million Americans, approximately 29% of the U.S. adult population, has a criminal arrest record on file with a state repository. In Massachusetts, there are about 2.8 million individual criminal records, and approximately 20,000 people are discharged from Massachusetts correctional facilities annually. All of them have CORI, and many thousands more have CORI that have not gone to prison, many of whom are on probation. The baseline information includes convictions and pending charges, but it can also include juvenile conviction information, cases that were dismissed, cases continued without a finding, those that resulted in dropped charges, and not guilty findings. Criminal justice agencies have full and complete access to the CORI information, and those are the prosecutors, police, courts, corrections, parole, probation. But there's also statutory access granted to certain agencies and vendors like departments and private vendors under the Executive Office of Health and Human Services, housing authorities, schools, and organizations that deal with children. The discretionary access is granted at the discretion of the Criminal History Systems Board, and they grant that access when they believe the public interest outweighs the privacy interest of the individuals with CORI. Security companies, long-term health care facilities, campus police, adoptive, and foster parents also have access. Then there's public access, and it's available under specific circumstances to the general public upon request to the Criminal History Systems Board. It can be on a person who has been convicted of a crime that was punishable by a sentence of 5 years or more, but has also been convicted of any crime and is currently serving a probation or incarceration or under custody of the parole board, is within a year of release of a conviction of a misdemeanor, or within 2 years of release of a felony conviction, or denied release on parole and returned to custody, or for having violated that parole. Some of the facts about CORI is that a felony conviction stays on the record for 15 years, and a misdemeanor conviction stays on for 10 years. Non-conviction information cannot be expunged from a report, and non-conviction information may be dismissal, not guilty findings, things like that are continued without a finding. The person who has CORI is also allowed to see his or her record after applying to the Criminal History Systems Board and paying a $15 fee, although it's our understanding that that is frequently waived for those who are indigent. One of the more important issues here is that CORI is not verified by fingerprints. The record is based on name and date of birth provided by the accused. And we heard numerous stories from virtually every party that we talked to, including law enforcement, that this is one of the primary sources of inaccuracies. because people at the time can give a false name and a false birth date or even have false identification. And since there is not a fingerprint or some other positive identifying possibility to really add to the CORI so that you can absolutely determine that it is that person, that results in a number of the inaccuracies. Obviously, there's human errors in recording things. Those are, more difficult, but there are ways to deal with that. Employers are also not statutorily required to share CORI with a job applicant and can use the report prior to making a job offer. The CHSB is currently in the process of adopting some regulations requiring employers to share the report with the person who has CORI. Some employers did say that they use a CORI report to screen applicants, often without actually reading the report, because many of them don't know how to read it, and it's just one of those things that tends to screen people out, regardless of what other qualifications they may have. There's also been a huge number of changes in the volume of CORI requests, and I think this is one of the things that really struck us, and in some ways we were amazed that the system works as well as it does, given the changes that have occurred over the last several years. Housing authorities may request CORI for any prospective tenant. Health and Human Service departments and their vendors, departments of mental retardation, public health, elder services, child, youth, and family services, and some of their contract agencies are required to review CORI on all existing and prospective employees. Schools, camps, and children programs, again, are required to review CORI even for volunteers that may be working with children. There's also increased pressure in terms of just the volume of cases that some of these changes have made. There are now more than 10,000 authorized users, which is up from 2,000 users in 1993. That's a huge growth. And there are 1.5 million CORI requests processed annually, which is more than 5,000 requests a day. As recently as 1998, there were 400,000 annual requests. And in spite of that, the budget has actually decreased over the last 7 years, and the demand for shorter response time has increased. If you look at this chart, it gives you a pretty good visual depiction of just how much the requests have increased since 1998. Remember, in 1998, there were 400,000 requests. Now there's almost 1.5 million for 2005. The next chart shows you the budget. In FY98, when there were 400,000 requests, their budget was just a little over $5 million. In 2005, with 1.5 million requests, their budget is just under $6 million. The height of their budget was actually in 2000, which was a little over $6 million, about $6.5 million. So while the requests have gone up exponentially, the budget has actually decreased to not much more than what it was in 1998. We decided as a part of our research to see what other states were doing, and we actually looked at a lot of states around the country, but we are giving you just some information on some neighboring states because we thought those were probably the most applicable. In New York, all charges are supported by the accused fingerprints. Non-law enforcement access is limited to conviction information only. And remember, here in Massachusetts, there's lots of other information that is not conviction, that is not specifically conviction, that is accessible by others besides law enforcement. And also in New York, the state has the burden of proving the accuracy of criminal records once it is challenged, where in Massachusetts it's really the person with the CORI. They have to prove that, and often that goes to a full hearing before the court. In Vermont, an offer of employment must be made before the employer can actually access the CORI. It is also a fingerprint-based verification system, and they are part of the APHIS system, which is a tri-state criminal record database, and that includes Maine, Vermont, and New Hampshire. New Hampshire also has a fingerprint verification system. They are also part of the APHIS system, and non-conviction information is disclosed only to law enforcement personnel or the person who's requesting their own record. And the changes to criminal histories must be done within 90 days of the disposition. Connecticut automatically expunges certain offenses, and we have a fair amount of detail about that, which I'm not going into at this point, but they have a law in the book which automatically expunges some offenses. They have a single agency responsible for correcting the inaccuracies, and it's also a fingerprint-based identity verification system. Rhode Island can expunge misdemeanors after 5 years and felonies after 10 years. First-time nonviolent offenses also can be expunged. While I said before we didn't review all states, we reviewed many more states than this, and we did not find a single state in the country that did not have a fingerprint verification system. And I think that's a significant issue for us to talk about. Also, many of the states had varying ways of expunging records depending on the seriousness of the felony. It wasn't a blanket number of years for all felonies or all misdemeanors, because I think most of us who are in the criminal justice system realize that some offenses pose much greater risk to the public than others. Some of the challenges of the CORI system are that it's one system with really two different types of users. It's a very complicated report format, and I have to say most similar law enforcement data record systems, are complicated because they use a series of codes, and this one is extremely complicated, and if you don't understand the codes, it's very difficult to be able to read it and know exactly what it means. There's also inaccurate or dated information on CORI, and the report, again, as we talked about earlier, is difficult to correct if you think there is an inaccuracy. There's also appears to be a lack of clear guidelines for using CORI. And when I say that, that's not universal, but it appears that, for instance, many employers do not have specific guidelines for how they're going to use it, and so do some other agencies not have clear guidelines. There's also a very long period of time before a record can be sealed, and again, it's partly because there's really no discrimination between the seriousness of the charges other than a breakdown between felony and misdemeanor, and there are lots of different levels of seriousness in both categories, but certainly in felony convictions. There's also an unregulated sale of criminal records by private companies. The other thing that we found out as we tried to talk to people and sort of figure out what some of the issues were was to try to verify as many of those issues as we could. And while we did verify, at least anecdotally, that there are lots of inaccuracies, I think virtually everyone we spoke to could acknowledge that there were inaccuracies. We don't really know how great those are. And there's a bunch of data that we don't actually have, so it's difficult in some ways to know exactly what needs to be changed or how to change it when we're not exactly sure what the impact of some of these issues are. We don't know if the availability of CORI is making workplaces, schools, and programs safer. Certainly it would be from some offenders. Whether it is in its current form is another question. We also don't know how much incorrect CORI there is out there. While everybody will tell you there's some, and they see it with some frequency, we have no idea the magnitude of those inaccuracies. We also don't know how many employers are using CORI and actually have guidelines for its use. We don't know if CORI is the primary reason for high unemployment rates among offenders. Is it a higher reason than lack of skills or job history? We're not sure of that. We also don't know if the list of disqualifying offenses in the regulations really align with those that are the most likely to have recidivism and are most likely to pose a threat to the public. During this process, we generated a list of more than 50 ideas for solutions to reduce some of the problems with CORI, but we tried to boil that list down to a few things that we seemed to find agreement across stakeholders or that were significant priorities for any particular stakeholder. The first one was really to implement a fingerprint-based verification system and to develop some kind of tracking system to improve accuracy and accountability throughout the data entry process. I think the Lieutenant Governor actually spoke to that issue to some degree. To shift the burden of correcting inaccurate CORI from the individual to the state, to modify the form of CORI reports so that they are easier to read for non-law enforcement users. And actually, we had a couple law enforcement users say, this is really complicated stuff. It took us a lot of time to be able to really understand it. Also, to educate ex-offenders, employers, and the public about CORI. Offenders need to know what their CORI says and how to defend it when they have a job interview or make a housing application. Employers need to understand how to read a CORI report and what it actually says about the applicant so they can determine whether or not that person's record actually presents a threat to the business that they operate and to the work that that person might do for them. They also need to understand some of the benefits there may be for hiring people with a CORI, and one of those benefits may be long-term public safety for people who are stabilized and have a legitimate income. The public needs a better understanding of what CORI means and does not mean, and what its importance is in successful reentry. There's also some discussion about limiting the liability to employers who hire ex-offenders and create incentives, and also changing what the access might be for different folks. This created essentially three very dominant themes. One was access. Examine who should have access to CORI and what kind of information they should see. Should everyone have the same access, or should it be different for different groups? Education, which I talked quite a bit about, was it's really instructing the various users on how to read CORI and how to use it. And accuracy, in ensuring that the CORI report accurately depicts the activities of the person who has that CORI record, and that there's a process in place that is reasonable to make adjustments or corrections if there are inaccuracies. Our hope today is to have a very thoughtful discussion about the possible reforms and changes to CORI, especially those where there may be some broad agreement. While we may not be able to change the CORI system today, I would hope that this discussion really spurs some action, and that possibly those officials who are empowered to make some changes would bring together a small but representative group of people who could work with 2 or 3 significant recommendations, work out the details of those recommendations, and put forth proposals that could make a significant improvement in the CORI system without jeopardizing its very valuable public safety role. That's a way that we could turn this discussion, which we're looking forward to, into some action that could really be useful for our state. I would now like to welcome the panel to come up, and Reverend Ray Hammond, who's going to be our moderator today. We have a very distinguished panel, and I'll let Reverend Hammond introduce those, but it's my pleasure to introduce Reverend Hammond. Although I doubt that he needs much introduction in this audience, it does give me great pleasure to welcome him and to thank him again for moderating this panel. Reverend Hammond was one of the founders and is now the chair of the Boston 10-Point Coalition. He's a graduate of Harvard College and Harvard Medical School, and in 1988 he founded and became pastor of Bethel AME Church in Boston. He currently serves on many boards of directors, including chair of this Boston Foundation since 2002. He's also a director of the Yawkey Trust, the Boston Globe, the Citizens Bank of Massachusetts. It gives me great pleasure to welcome him, and we know that this panel and this discussion is in very good hands. Thank you all.
Thirty-second pause so you can all just take a deep breath, welcome the person next to you, something like that. That's good. Okay, all right. Thank you all for being here. The overflow capacity here says a lot about the response of this community to a very critical and pressing issue. This really did come out of a number of discussions that were held first around the issues of reentry. And time and again, both anecdotally and by virtue of the experience that they themselves and others that they knew had been through, ex-offenders who were trying to find ways to not only reintegrate their lives into our community, but to make the contribution that they very much wanted to make, found barrier after barrier. And we heard story after story. And community members and many community-based organizations expressed their frustration over the difficulty of getting over this barrier. And so we're thankful as we come today for the opportunity to really talk about what does this process actually look like, and what can we do to make it operate more effectively, so that indeed these issues of the right of the public to know and the right of individuals to move on, to grow, to become productive members of our society can be addressed. And so I want to thank first Elise and all the members of the Crime and Justice Institute for an excellent report that have got us off to a good start here. And also I'm going to ask right now, just before we introduce our panelists, just very quickly, because, you know, these kind of events can be a little bit stiff, you know. And I thought it might be nice, again, if we would just take the time, because you're undoubtedly sitting next to somebody, and in typical New England fashion, You're sitting there, they're sitting there. You're all occupying kind of your space. Nobody's going over the lines here, right? We're not bumping into each other. Why don't you just, lean over, introduce yourself. Let's kind of break down a little bit of the ice here.
Reverend, I'm going to go say give greetings to
Sure.
to the honorable.
All right. I'm always amazed at what happens when you give New Englanders the opportunity to really be warm toward each other. It's just something springs out. I think it's been repressed all this time. So this gives us an opportunity, and I hope establishes an atmosphere in which we can talk as a family about a very serious family problem. And I want to thank those who are panelists here with us today. Now, their full bios are provided in your packets, and you can refer to those, so we won't do the whole thing, but we're going to give you kind of the Reader's Digest version of some very prominent people and who are very committed and concerned about this issue. Starting on the left, your left, and of course my right, is Sheriff Andrea J. Cabral, sworn in on November 29th, 2002, as the 30th sheriff in the history of Suffolk County, the first female in the Commonwealth's history to hold that position, now responsible for the operation of the House of Correction, Suffolk County Jail, Suffolk County Women's Resource Center, Suffolk County Community Correction Center, and the Civil Process Division. Former prosecutor whom I had the opportunity to work with, and she is tough but caring. Andrea Cabral has a distinguished 16-year career in public service. And Ernest, also known as Tony Windsor, staff attorney at the Mass Law Reform Institute, Legal Aid Support Center from Massachusetts, a longtime advocate for reform of the CORI system. It was his organization that authored the CORI Reader, a tool designed to help lay people better understand the CORI system. Next to him, Ms. Barbara Redden, branch office manager at the JobNet Career Center facility at 1010 Mass Avenue in Boston. That branch office is responsible for providing job readiness, job placement services to over 500 people every year, including people on public assistance and persons who've been formerly incarcerated. She has been a tireless advocate for countless persons affected by CORI and has served as a trainer for employers around CORI issues. Barry LaCroix, Executive Director of the Criminal History Systems Board, for which he has worked for over 12 years in many different capacities, including serving as Executive Director since 2001. He's the guy who's had to be there through that enormous increase that Elise talked about. The Criminal History Systems Board, otherwise known as the CORI Board, is a state agency responsible for determining whether non-criminal justice agencies can access criminal records for screening purposes. And Barry has overseen the agency's key challenge of responding to that increased demand. And last but by no means least, Senator Jarrett Barrios, Democratic State Senator representing Cambridge, Chelsea, Everett, Charlestown, and parts of Alston, Brighton, Revere, Saugus, and Somerville. Do we leave any place out? All right. As our staff is right on top of it. He serves as the Senate Chair of the Joint Committee on Public Safety and Homeland Security, has extensive experience working with law enforcement and community leaders to prevent and prosecute crime, and has several legislative achievements that address key public safety issues that we all care deeply about. And just before we launch into our first question, I do want to take an opportunity to recognize Representative Mike Festa, who I believe is over here. Thank you for being here today. Well, we've had three areas, I think, lifted up before us from this report: improving accuracy, access to CORI, and the issues of education. And we want to take those in turn, again, not for the purpose of suppressing a very lively discussion, but putting some framework around it that allows us going forward from here to make some progress. And so I want to start with this issue of the fingerprint-based verification system. Now, as was noted here, we're one of the only states that does not utilize a fingerprint-based system. Now, there's been a broad consensus that that system would improve the accuracy of CORI records, and it was learned through our research that while it's not yet implemented, Massachusetts has developed a new offense-based tracking system where it might be possible to attach fingerprints to offender records. The question becomes, when is it anticipated that this new tracking system will be implemented, and is this enough? Recognizing that not everyone is initially fingerprinted, how does this system actually get implemented? And I want to toss that hot potato into Barry's lab.
Thank you, Reverend. Just a point of clarification, Massachusetts does have a fingerprint-based system. There's what's called an automated fingerprint identification system. It's an AFIS. The state police maintain it. Under state law, anytime you're arrested for a felony or a drug offense, the arresting department is required to forward those fingerprints to the state police, and those are in turn forwarded to the FBI. The problem we've had in Massachusetts is we have that fingerprint-based original arrest. And then we also have a second record, which is created by the court. It's called we all call it CORI. It's really the Court Activity Record Information File. It's a summary of your arraignments in the trial courts of the Commonwealth. So what we've had is we've had a fingerprint-based arrest event, and then we have a second event, which is the arraignment in one of the trial courts of the Commonwealth. We've had trouble. The problem we've had is combining those two records together. To do that, you really can't create, if you really want a biometrically based fingerprint record, you have to go back to the original arresting event that has the fingerprint. So for a long time, the courts have their own system, the public safety have their own system, and the systems weren't talked. We've actually got to the point now where, first of all, we've all agreed to use what's just basically a tracking number. So we all share a number. Once someone's arrested, you assign a number to that event, and then each step in the process, whether it goes from police to prosecutors to corrections to the courts, each event carries that number, and then you can link all the records together. The courts have formally adopted, Chief Justice Mulligan formally adopted that process, I want to say late last fall, maybe early this winter. So we're on the same page now where we can start developing that interface. Now we have the technical people actually developing the interface. We have a pilot project now with the courts, we're doing it with one court, where they're actually taking, when they create a criminal complaint, when they start creating the CARI record, they're pulling the information out of the original arrest information. So there's much less likelihood of any data entry problems, and you have that biometric identification. So we're piloting with one court now. We hope to go more widespread, fairly soon. And that in itself is an interim solution. What the real solution is going to entail is when you're arrested at a police department, when there's an arrest event, that information is automatically forwarded to the district attorney's office, where they will incorporate into their system, forward to the sheriff's office, forward to the administrative office trial court. A lot of the groundwork has been done for that, and I think one of the more important things is the governor issued an executive order which creates a governing council which gives all the stakeholders a seat at the table to kind of govern how this process will work. So I expect it to happen fairly soon. Now, we have to be careful when we say fairly soon. Once we create a fingerprint-based criminal record, that's great. We're close to that. But it's different to creating a fingerprint-based criminal record and then actually making a query based on a fingerprint record, right? We have a fingerprint-based record. We know it's Barry LaCroix, and we know this is his record. But to make an exact match, you have to submit fingerprints to get that record out. So right now what we're doing on the CORI checks, you're sending a name and date of birth into CHSB. To make a really perfect system, or to the extent to make it perfect, you'd have to submit fingerprints as well. At 1.5 million requests a year, that's a tremendous burden on the fingerprint machine that the state police has that reads that, on their fingerprint examiners, and just on the who's going to capture 1.5 million fingerprints. It's a lot more work to capture those fingerprints than it is to just submit a name and a date of birth and a social security number to CHSB. So, I think really on the criminal side, we're getting very close to tying those two things together, but there's going to be a lot of work and, quite frankly, a lot of resources if the decision is to submit fingerprints electronically to do a CORI check for non-criminal justice purposes.
Okay.
This is my first time. Can you all hear me in the back? Okay. A couple years ago, the Senate and the House joined the Senate in reorganizing a number of the agencies, including the Crime Lab, the Office of Chief Medical Examiner, and the Criminal History Systems Board, under one Secretary at Public Safety. The notion was we wanted to see more leadership. We wanted to see more leadership in the Executive Office of Public Safety for what we would think to be systemic intractable problems like the one that we're wrestling with here today. It has been, Jane Tewksbury was the first named at that. Jane is no longer there. We are hoping, because Barry obviously does a great job and we're looking forward to this, but we also, I think, need to see leadership in the administration sort of a little higher up, because it's that person that liaises with legislators on budgetary matters, because as Barry's just mentioned, this is going to take some, it isn't just going to take good ideas, it's going to take funding and sort of a lot of support from legislators and the governor's office too. So as we talk about it at the agency level, and there are many other things I'm sure we're going to talk about at the agency level, I think it's important for all of us to keep in mind, sort of as a systems issue, there are many layers at which we need to make sure they're engaged. We're anxiously awaiting the new undersecretary to be named by the administration, and hopefully that will be somebody who's committed to this long-term reinvention, combining CORI together with the fingerprint arrest records, and getting one system.
Well, the fingerprint certainly allows us to make sure we get the right person with the right record. There's also the question of the data that's actually entered. There are a lot of places along the way where, in fact, data can be put in. How do we, in fact, have quality control to make sure that that data is accurate and that there are processes for getting it? Do we need a password system? Are there other kinds of insurance we should be having? To start with Sheriff Cabral.
Well, I think that is a full second part to what we're talking about here. The people who enter the information, and there are some systemic problems, but there's also human error in the information. I think, in my experience, given the vast amount of information that is collected on records, it is stunning to me how accurate what we have is. But there are mistakes that are made, and people often don't find out about those mistakes until the mistake has negatively impacted their ability to get a job or their ability to get housing, or they're being arraigned for a trial for a crime they didn't commit because their brother or their sister or their cousin used their name and their date of birth. So I think that one of the things that you have to have is a password system for people who are entering the information into the system. You have to be able to track the entry of that information back to the person who did it. It's really a quality control thing. And I would think that any system that has people inputting data will want to be able to track how accurate people are. It's not a sort of a system designed to go after people, and sort of Big Brother looking over their shoulder, but you have to be able to make sure that people who are entering information are consistently entering it accurately, and if they're not, then they need additional training, or perhaps they need, to perhaps look for another position. But I really do think that but the only way that you know that is to be able to track those mistakes back, and if they're constant mistakes, then I think that that's an issue. You can also set up any computer system to keep a person from moving from one field to the other until certain kinds of information are entered. So in addition to inaccurate information, sometimes you have the absence of information. I've looked at many criminal records, got to a certain point and thought, okay, well, what happened then? And I simply don't know because it's simply not entered into the record. So that's another, there are very, very simple, very fundamental ways of making sure that the information that is actually entered is accurate.
I think these plans to make a complete change in how we link up what the police do in taking fingerprints with the court system is a terrific idea, and I hope it happens in the lifetime of all of us. But in the meantime, what do we do for somebody who does have an identity tangled CORI? Is there an official way that those people can go to the Criminal History Systems Board and follow a procedure that's well known, that's in the regulations, which tells people what they do, and makes it very clear that it isn't just the Criminal History Systems Board that has responsibilities here, but the local police departments or the state police, others in the criminal justice system who do the fingerprinting. Right now, there's no such procedure. We've suggested it to the board in connection with their forthcoming regulations. We hope that we can work out something with them so that there is something in the regulations publicly available to people to realize that there is a process, an official process for untangling the mix-ups. The other thing is that we've suggested that there be an ombudsperson within the Criminal History Systems Board whose job it is to help people in a practical way to deal with these identity tangled problems and other problems in the system. I think Barry feels one person alone would be so overworked that she would die in the first 90 days, and that may be true, but you got to start a long trip with one step, and one step would have somebody in the Criminal History Systems Board bureaucracy whose job it was to help people who have these god-awful problems. And believe me, they are terrible for people in getting this disentangled. So let's begin this now before we get the perfect system where the CORI and the fingerprinting are all integrated. I think that's a great idea, but it's going to take a long time and it's going to take significant amount of funding.
Barry, any thoughts about it?
Sure. As far as one of the things the legislature did is they required CHSB to promulgate regulations that provide practical assistance to an individual who's seeking to correct his record. In the past, what's happened is generally the CHSB generally doesn't create records. We're a big storehouse of records. So if someone called with a record, with a problem, we'd say, well, it sounds like it's the CORI file, which is created by probation. You need to call probation, and here's the, speak to the chief probation officer of the court where the person was corrected. And that was, that, quite frankly, that advice was not sufficient. So clearly the legislature told us so. So we're in the process of drafting some regulations that mandate that we have a process. One of the things we have to do is we're going to publish and have on our website just very practical assistance for someone how to go about it. So you can just download the information, or any advocate can get the information and give it to an individual to help him or her correct a record. And then at the other end of the spectrum, we have a very formal complaint process that if you have an inaccurate record, you can petition the board to have it changed. That's very rarely used because within the criminal justice community, if the record's inaccurate, we want to correct it. So you shouldn't have to get to that process. You should be able to, if something's incorrect, we want to correct it and to get there. So in an interim step, what we're looking at doing is creating like a worksheet that'll give someone kind of the steps they need to take and publish that to go through there. Now, that's how to correct a record. That's if, I have a record and it shows that I had an offense and it was continued on this date and it was actually dismissed and no one, how do you go back and get that record updated? The second thing that Tony alluded to was where you have people who have shared names, where you have two John Smiths, or you have people who sometimes it's purely innocent. A friend has used the person's name and date of birth, and it shows up an alias on the record. Sometimes there's collusion between the people. Those are very difficult to pull apart from one another, because what you have to do is you have to go back to each arrest or each arraignment, each event in there, get the police report, were fingerprints taken, were photographs taken, them, and compare them there. And those are difficult to do. In some situations, you're not going to have fingerprints. You're not going to have photographs. You're going to have a hard time separating, the two. What quite happens with twin brothers. They'll share their names. So that is going to be a bigger challenge. And I'm not sure that, and we work with Tony on this, there's not an easy answer to that. There is just not an easy answer to that, but it's going to be a lot of legwork from whoever is assigned that responsibility to get the information. Some of the information may not be there.
I want to just comment on that. The system as it currently exists, though, leaves the burden entirely on the person who has the mistake. And yes, it's true, you can say, well, sometimes maybe it's a twin brother. I think far more often it's the case that, well, a couple of things, whether it's an innocent or not mistake, there are often times, and I've had at least 5 constituents in my 7 years in the legislature, who've had their identities, in fact, stolen by somebody else, or if not stolen, their Social Security numbers taken, they get a driver's license taken, and completely without their knowledge. And now they are, 5 years later when they discover this, they have a tremendous burden. And for them to have to bear that with, even when you develop regulations, which we're really hoping you do very soon, when those regulations are promulgated, what some of us would like to see is in that, or in some subsequent regulation, the department, the Criminal History Systems Board, assuming responsibility for proceeding it and not expecting folks without deep knowledge of the system. Many folks have day jobs to sort of figure out, without hiring a lawyer or some other great expense, how to negotiate the system. It has to be something which is user-friendly, user from the perspective of the person making the complaint, so that they don't have to, that they can do it with an ombudsperson, if not with an ombudsperson, with the person they're calling on the phone or they're visiting at the board.
I would like to make a comment. We see the people who are the people with these problems. And what I'd like to see while this is all going on is this person may not be able to gain employment because they have a charge on their record that's not theirs and they're trying to figure it out. This will take time. But what I'd like to see is a document saying, I am in the process of making a correction to my CORI for this charge, which I have not committed, and here is the document and the process, so that I'm not waiting 5 years for fingerprinting or whatever, because our clients are not getting jobs because of these mistakes.
Thank you very much. Let me raise this because we've, I think, brought out a number of excellent points that address this issue of improving accuracy. Let's talk about who ought to have access to that record, preferably when it's cleaned up and made correct. And as we do that also, just want to take a moment, Councilor Steve Murphy and Senator Diane Wilkerson, want to just acknowledge their being here. Are they? Here we are. Great. Fantastic. Fantastic. All right. And I'll ask Barbara maybe to follow up with that. How do, I mean, clearly there's an interest in law enforcement. Clearly there's often concerns that employers have that might be addressed. But who ought to be getting access to this record, and what should they be getting access to?
Tony and I work very closely together, and I think convictions would be the information that might be something that someone would have access to. I'm not sure you can hear me. Because having trained the Office of Health and Human Services, they only became complicated by all of the information that they saw. This particular client was, by jury trial, dismissed and found not guilty. But having all of this information on there was just confusing. So what I'm saying to you is, whoever has it, it should be relevant information.
Okay. Can everybody hear? I know we're having a little trouble with Barbara's mic. We're going to get another one. In the interim, let me just repeat the point that she was making, that at the moment the record is often, quote, cluttered with a lot of non-conviction information that employers are having quite a bit of trouble wading through, and in many cases are just assuming that if there's anything there, it's a cause for rejecting a candidate. Yes, Tony.
I think one thing we should realize is that a lot of this, what I call junk CORI, which aren't convictions, but are charges that were brought and ended basically in a favorable way in the sense that the person was not convicted. That junk CORI is being sent out to thousands of people, sometimes legally, because the legislature passes a statute saying that this kind of CORI, this extent of access, should include everything on there. And the words that the legislature has used is all available CORI. That means all that other junk which are not convictions. Most people in this country think that having a criminal record means you were convicted of something. We have courts to decide who should be convicted and who shouldn't be. The notion that you're innocent until proven guilty is a fundamental notion of our whole criminal justice system, albeit that Justice Rehnquist thinks it's a mere rule of evidence. We shouldn't be sending out this junk to superintendents of schools who now have to do CORI checks every 3 years, even on their employees that they've had for years, because the legislature in 2002, in November, put a law through that expanded access to CORI by 500,000 people. 500,000 CORI reports a year. That's the estimate that was made by Barry's organization. We're sending this non-conviction CORI to thousands of users. They don't understand the difference between assault and battery with a dangerous weapon that ended in a dismissal and assault and battery with a dangerous weapon that ended in probation or jail time or something like that. Those are crucial differences in the American justice system, and it's not now being reflected in this CORI system.
Director LaCroix and then Sheriff Cabral.
I'd agree with Tony on that. In the board's general position, when they determine the extent of access, there's really three categories. There's conviction information. There are cases that are still pending, and then there are cases that I call arrest data, but it's just an arrest that didn't lead to a conviction, maybe was not prosecuted, was found not guilty. There are three categories. So those three categories, when the board makes the determination on what should go out, the board says that the conviction in the pending cases should go to the employer or the school, whoever is doing that. However, the legislature has mandated in many situations that the entire record go out, so that raw arrest data that doesn't reflect a conviction does go out. The board does have the authority and has used the ability to send out that arrest data, and I think in 8 cases over the last 12 years. The one I can remember closely was the state agency that licensed school bus drivers came to the board and they said, hey, we really want to see the arrest data because we're concerned about sex offenders who have preyed upon children, and there may be situations where we couldn't get a conviction because the child wouldn't prosecute. So we really want to make sure that we have that information. We'll have appropriate safeguards. And the board, in those situations, 8 of those, has said, yes, we should provide that raw data. But other than that, when the raw data goes out, it's because of legislative mandate, not because of what the board dictates.
I say this toward a productive discussion, and certainly with absolute due respect to what is clearly a commitment to reforming CORI on your part, but I take exception to junk CORI. What is on there that, and keep in mind, CORI was designed originally, when I became a prosecutor in 1987, the only people who had access to it were law enforcement people. That's what it was designed for. It is of relatively recent vintage that employers and people connected to public housing and a number of other organizations, in large part due to the civil liability that has flown directly from people being sued for hiring people who have criminal histories who subsequently hurt someone. Now, this is an outgrowth of where our society has been heading in terms of being overly litigious, but also having more to fear, or so we perceive, from people who are ex-offenders. But keep in mind that the system itself, and I hear there's a certain level of sort of the Criminal History Systems Board needs to ... The system wasn't originally designed to do that. Now, like any system, it is capable of reform, and clearly people intend for that reform to happen. But the information that is non-conviction information is not junk. Law enforcement uses it every single day. I can look on that. I know what a person that I have that I'm prosecuting. I can look at that record. I can go back to different jurisdictions that have arrested an individual, that have information about that individual's actual identity, where they live, the circumstances of what they may have been charged with, but perhaps not convicted of. And I can use that information to help the prosecution in my case. So it is not junk. It is on there for a reason. And that's because originally it was only intended for it to be for law enforcement. As we move toward this reform, and we now know that more and more organizations and agencies have access to it, it simply becomes, not simply, because nothing about this is simple, but it becomes a situation or a decision or an issue of how do we limit access to balance the rights of the individual against the organization, agency, or other individuals' right to know. And it's always going to be that constitutional balance that government attempts to achieve between itself and individuals who want access or need access or don't want people to have access to information. So I really think that sort of distinguishing the information as on a CORI record as valid versus non-valid is less productive than talking about who needs access to good information that is going to help them make a fair decision versus who needs access to the information in total, and that would be law enforcement all the time in the courts and corrections.
Do we need 2 different versions? One, coded, complete for law enforcement, another one more limited and readable for the for the employer or the larger public.
And I think you can do that. I think you limit access just the way you limit access in the House of Correction. I have access to everything I need on the computer. There are employees that have limited access to information about inmates, about coworkers, and so forth.
I would just add to that, it is endorsing everything the sheriff has said about the importance of having sort of different levels of access, more access for law enforcement, less for those who don't need it, perhaps limiting it to the conviction stage, which is something I support only. It is also a question of interpreting the CORIs, and there being not necessarily clarity on the part of agencies as to what to do with this information. Okay, so I've read the CORI. What is required of me as a result of this? The Executive Office of Health and Human Services issues guidelines, very stringent guidelines. There's an agency, my friend Katya Fells I saw earlier from on the rise. I remember a story where she was telling me she runs an agency that doesn't deal with youth. They don't deal with folks over 65. They deal with homeless women sort of between, 18 and 50-ish. And they are compelled, they believe they need to follow EOHHS guidelines, which are very conservative. They err on the side of safety. I think we're always going to find folks erring on the side of safety where they don't know more. It is EOHS's responsibility, and perhaps it is truly the Criminal History Systems Board responsibility to really make it clear to agencies, whether through regulations or through directives, interagency directives, as to how to give these far less sophisticated consumers, the agency executive directors, who are in the business of doing their good work and not in deciphering queries and making very important, oftentimes with liability consequences, decisions that are always predictably going to result in a risk-averse decision. Well, since we don't know, we'll just depend on what EOHS says and we won't hire the person. We have to understand that that is as much, I think, a part of the problem, that discretionary point, and give folks the information they need and give them guidance in the exercise of their discretion as well.
And where should that come from? I mean, especially in the context, I guess, of the EOHHS regulations, which have had a pretty powerful impact. Yeah.
See a couple of things on that to respond. CHSB's position was always that, our mission was to provide the information as accurately and as timely as possible, and that's what we endeavored to do. We felt that we did not have the qualification to determine what would make someone a good daycare worker, a good Little League coach, a good employee of the Sheriff's Department. We're kind of a technology group. We wouldn't have that responsibility. So we always left that, EOHHS had some guidelines for their providers and various things like that. Unfortunately, I think what's happened is without guidelines, people were doing what the Senator said. They just risk-averse. There's a record. They don't know what to do. So we have done some research, and we're getting ready as part of our regulations we're promulgating. We're going to provide some guidance that are going to be more more general, I think, than the EOHHS guidelines. Things like, I think there are 10 or 11 criteria, but these some federal research on this. You look at the nature of the offense. You look at the age of the offense. You look at the age of the offender when the offense was convicted. You look at the amount of time since the offense was convicted. And those guidelines there, and you can use those sort of things to make a determination. We will provide that information to these agencies. We're also going to mandate that they have a policy that says, this is how we'll use it. Either use the EOHHS guidelines, use the more general ones we're providing, but you have to have some policy on how you're going to use the CORI, and that's part of the regulation process we have now. As far as, so I think we're making some headway on that. We'll see how we set to promulgate the regulations by July 1st, so that should happen. As far as the education, that's been a real challenge. And some things I take exception to. The judicial system, the criminal justice information system, is not that simple. So I'm not sure that the best answer is to take a complicated summary of a person's criminal arraignments or history and try to dumb it down to make it readable for whoever is going to be receiving this information. I think a better policy is to train that person how to read it. We have funny things like continue without a finding, whatever that is, whatever that means. I mean, I just don't think it's a good idea to say that's either a dismissed or that's a guilty. I think you have an obligation to train the readers of this what a continue without a finding is, which isn't easy to decide what that is. We have been, Carol, I mean, it's not that easy. So we've spent a lot of time we've put a lot of effort into a website to create that information. We put all these, it's very difficult to read. Well, we created a website that you have a sample CORI form on there. If you hold the cursor over the field, it explains what the field is. If it's over the dispositions, it'll tell you what a disposition, explain what a quaff is, what a dismiss is, what a not guilty is. The problem is it's a passive system, and I don't know how many users of this CORI system have actually taken the time to go onto the website and learn that. And my feeling is that not many people have done that, and so all the efforts we've done to make the information available, no one's availing themselves of that. So, should it become mandated, and if you're mandated, how do you enforce it, and, what resources are available to enforce it? So, the education, I think, is key, but I don't think it makes sense to, dumb down a report.
I just wanted to say a word or two about the Human Services regulations, because I don't think I'm being heard. They have an enormous impact, and I think the worst impact of those regulations, and I note that we have the General Counsel of HHS here today, is what we call in the CORI project at Mass Law Reform, the hoop jumping procedure. They have a table A of crimes that somebody in an ivory tower thought up as were the worst crimes of all. And they initially put out a diktat back in 1996 that anybody who has a crime on this list, no matter anything else that's happened in the life of that person, can never be hired. We brought a lawsuit. We won the lawsuit. The Superior Court judge said, you can't do that. You have to have a meaningful procedure for the person who wants to be hired to be able to show that he's not the kind of dangerous person that this thing presumes. They came out with a series of regulations now. They're properly adopted as the regulations, but they basically have this Table A, and in order to hire a person on Table A, what you have to do is find a qualified mental health professional, which is defined as a psychiatrist, psychologist, or licensed independent clinical social worker, licensed in Massachusetts, who you find somewhere, not in the yellow pages, who's had 1,000 or more hours treating and evaluating persons with behavior disorders. This person you hire, and it costs between $1,000 and $2,000, and we all know human services agencies have plenty of money for this kind of expenditure, who comes in, sits with your applicant, talks to the applicant, then looks at the records, talks to other people, and then makes that writing, which makes the prediction that this person is probably not a danger to your clients. How many people have gone through that hoop jumping? If I had time at a CORI training, I could tell you some stories about what's happened. But it's expensive, it's time-taking, and it ultimately is based on the notion that psychiatrists can make better predictions as to future dangerousness than seasoned human resources people or people who simply have common sense. Those regulations are a disaster for people who have serious crimes, who have changed their lives around, and there's a process that is so difficult, so expensive, and so unrealistic that those people are just shut out from working in a field where many of them would be excellent as drug counselors for people who formerly used to sell heroin and got over that and have changed their lives. So we have a lot of things in the system. It isn't just the Criminal History Systems Board. It isn't just the legislature. We have a major part of the state administrative bureaucracy, which is a regulation which is a disaster in many ways. I should say that if you go through this hoop jumping, and then you're meant to do the kind of common sense thing that Barry was talking about, what crime was it, who was hurt, how long was it, what other crimes were there, what's happened in the meantime, what rehabilitation, and so forth. Those are the common sense part of the regulations. That one section is really good in the human services regulations. I hope they don't repeal it. But the hoop jumping stuff is terrible.
Barbara, you've had some experience. And also I want to ask you to just... in the back. Yeah, definitely another group over here. That's right. Making their presence known. You've also had a little experience, too, with this process of educating employees. We comment on that as well.
Absolutely, but I just want to make one comment with all due respect. The junk, and I'm not saying junk, but some things charges should not be on someone's CORI. For instance, there was a woman that I was case managing who had a charge of failure to send child to school. You see, and she was devastated because here she was, decent woman, never did anything, and she has this charge. And there's a whole educational process as to what is on the CORI and what does it mean. So she was just depressed. She was doing nothing until we discussed this. So, I mean, that's just a small example, but there are things on people's CORIs that have no relevance to anything. I'll answer your question.
Just the point about educating employees also.
Okay.
Yeah.
Educating the CORI, if you've ever seen one, is very, very complicated and difficult to read. And if it's something on there, you must be guilty of it because I can't read it, so it must be something. And you may have been found not guilty. Let me give you an example. I gave the example of at Office of Health and Human Services when I trained out in the university there at out in Marlborough. I gave them a copy of a CORI, and I asked them, would you hire this person? Now, There was like almost 100 people there. 4 people raised their hands after reading the CORI and said yes. The person had a master's degree, was found not guilty of crimes against the elderly over 60. It was a jury trial. And after explaining what was said, they wanted to go into a lot of discussion. Well, I'd have to look at them and say, did they do this, or maybe they pleaded, or maybe they had a good lawyer. That is not the issue. The person was found not guilty by jury trial. Where do we cut it off? All right? Is there what discussion? Here I am, ready to work, and I was found not guilty. And I'll give you an example. My mother has Alzheimer's and dementia. She's over 60 years old. Being psychotic, she may have charged me with a charge of cruelty to her and went to court or whatever. You don't know what the circumstances are, and you're never given an opportunity to explain. Had you sat down with me and said, okay, you have a charge here, and we just need more information, would you explain the circumstances regarding these charges? And then perhaps I could have explained, but you would have given me the opportunity. That wasn't the case. No, we need more information. And they would have all this dialogue with their peers and not talk to the person whose application it was. So education is needed. When is enough enough? If I'm not guilty, I'm not guilty. Should you hire me? And should you not? And should you explain it to me? I am not going to hire you because we have questions about you. Because you might have done something because you have 2 charges here. And I think that is unfair, and I think it's not relevant, and I think we have to have education to get over this.
We do. I don't think that we disagree much. I mean, I think Barry was saying talking about the dumbing down of the record, but I think that was, by and large, I think everybody on the panel agrees that law enforcement needs to have, for the most part, unfettered access to this information.
That's true.
Right. And that people who are not in law enforcement need only to have that which might be relevant to their decision.
Absolutely.
That becomes complicated because, as Barry said, how does a system or an agency stand in the mind of a potential hiring agency and decide what makes a good daycare provider? I think with authority comes responsibility. Agencies and organizations that have access to CORI should be provided to show that they have taken the training, so the information isn't passive. If you think that you need this information in order to make informed decisions about who will live in housing over which you have jurisdiction or who you will hire, then you must be able to show that you're able to take that information, process it appropriately, and apply it appropriately. So it's burden sharing. Clearly, the Criminal History Systems Board is not equipped to make sure that people get the information, but those that want the authority and discretion to use the information should have to show that they're able to handle it. And so I think we completely agree that there needs to be unfettered access on one end, restricted access on another, and then some affirmative effort on the part of people who want this information and need it and are statutorily or otherwise authorized to have it, that they can take it and they can use it. At least raises the presumption when they prove that it's being properly applied. There will still be issues and mistakes. But I think that's one of the ways that you can sort of balance it out.
In the interest of, and I'm going to ask Senator Barris in just a second, just because I want to make sure that we do get some input from the audience as well. I was going to ask each of the panelists, and we'll start with Senator Barris, if you could hone in on one thing that would really help to move the needle here, really begin us down this road, legislatively, non-legislatively, in the realm of education, whatever it is. What would you think was a critical piece to be dealt with? Now, can I take as yours the importance of that?
Trying to save time.
He is. He totally is.
Trying my best here now. But that we do, in fact, need this distinction in terms of who's got full access and who's not, and
yes,
that there be the requirement of education if you're going to get access to that information.
Right, and the appropriate quality control measures on the part of people who enter the information, and the appropriate funding for the agencies who are going to be tasked with putting out this information and educating people, and that includes the Sheriff's Department, who will probably be asked to educate all ex-offenders leaving their facility.
That was really slick. She got 5 in there, I'll tell you. That's great. That's great. Okay. Senator Barris.
I just got to say, the way, and quite simply, given that we're moving to a level technologically where we can accomplish unique identifiers for the actual cases, with tied to folks' fingerprints, you can do the same for folks who want to access. If somebody wants to access, you have a designated employee at the agency that's statutorily required to do the CORI check. For them to actually have the access, you can require they take a 5-hour or 10-hour course. And when they do that, they get a number. And with that number...
And they get tested at the end.
Bingo.
To be sure they learn.
It isn't rocket science, right? The private sector does this.
Right.
The private sector does. And so it's not just about talking about the responsibility they have. We can actually make sure that they're educated. Now, that's not my one thing. I just wanted to amplify her one thing.
That was good.
My belief really does come down to, if there's one thing, is developing sensible rules around access. We talk about two categories, the gentleman's cell phone.
Can I turn this off? Everybody else, don't do what I did. Turn yours off. Gee, I'm sorry.
I think of it, we talk about sort of the law enforcement, non-law enforcement dichotomy. I think of it really in terms of three categories. Yes, there's law enforcement, and it's very important in most instances for folks who are tied to that particular case in some way to have unfettered access. For folks who are statutorily required, I think the issue is one of, convictions, and while we won't call it junk information, out of respect to the sheriff, information which is perhaps confusing and not relevant. And then there's everybody else, and increasingly, and this is where you see the trend, is other folks wanting to get information, because we are as we sort of progress in the 21st century, we sort of think that we have a right to all information about everything. People's medical records, people's, transportation. The MBTA has this Charlie card. It's tracking all of our movements on the subway. Of course they should have access to all of our information where we go on the subway. Here, a private employer, and if they can't get it through the Criminal History Assistance Board, they're going to buy it on the private market. And this is another very important issue, because they don't need to get trained on the private market about how to interpret this information. And that's a third distinct category. And I think we need to think about who can and who has access to sort of transmit this information for folks who really don't have anything but sort of a curiosity, or maybe their insurer tells them there's a liability interest, but they don't have interest in actually training themselves in how to use it. And that's a third, and I think even more restrictive category than those who are statutorily required to get access. So that's my one thing.
Thank you, Reverend. It seems to me that earlier Elise showed us the chart that showed how the increase in the CORI checks was going up, and we're doing a tremendous amount of CORI checks there, and much more than we've ever done in the past. It doesn't seem to me that we've built the safeguards at the back end of the system that make sure that the information is being used fairly, intelligently, and giving people whose record is a fair shake. And when you say we, CHSB is providing that information, that back end has been silent. It hasn't been. There have been no resources dedicated to that. And we're going to take steps now to try to make them have model policies. Maybe we come up with an exam so they can try to read a thing and interpret that. But if it's still passive, if we can draft, we have the resources to draft those exams and make them give them and do that. But my feeling is if you don't audit these users, if you don't send someone in the field and make sure that these recipients have actually used the tools that we've provided in making fair and objective decisions, then I think everything may not be for naught. So, I think we've done a lot of CORI checks now. We have a lot of work to do to tie the fingerprints to the court records, and we're going to get there. But even once we get there, we still need to make sure the information is used in a fair manner, and I'm not sure that has been done yet. And that would be nice to see from our perspective, that we know it's being used fairly.
I think as far as I'm concerned, I just want to take a moment to say where we're located. We're located at 1010 Mass Ave and at the 90 Washington Street DTA offices in Roxbury, Dorchester. So we come from the community. I see the people. We see all these people that you're talking about. And we're right next to the jail. They can walk from your jail to my office.
And they frequently do.
And they frequently do.
Good.
And the point is, the compassion. People have to be compassionate. And one thing I'd ask is understanding and a commitment to training the people that are coming. They have to understand their responsibility, but also their limitations as to where they can work. Because as anyone who's job ready, you have to prepare the person for their jobs and where they can work, but you also have to prepare their attitude and the sense of explaining and sharing what it is that they've done, and it's in a positive way, putting a positive spin. So we're talking about money. We're talking about commitment. We're talking about clothing. If you come out of your place to my place, you may be homeless. They go to food stamps. They don't have a phone. We have a phone system. They don't have a resume. We're doing all of these things. We can't get a person a job that quick in this community. We also need help with money. Okay, there's certain offenses that are certain jobs are more reticent. In other words, truck drivers, driving, helping people get their license back. You know, you could have offenses, get a job as a driver, but if your license is messed up with fines and everything, we need money and a commitment of that. We also need employers who will look at bonding, who will look at a person, who will give us feedback. I need feedback. I'm going to ask for feedback from my friend there, you know, on everything, because with feedback we can do things with if you're motivated. So what we're needing is education, we're needing compassion, and we're needing just a commitment to our clients. Is that more than one?
Of course it's more than one, but nobody else is stuck to one, so why should you? Go ahead. That's okay.
My access issue is sealing. We have statutes on the books for sealing misdemeanors and felonies. You saw in Elise's PowerPoint that it's 10 years before you can get a misdemeanor sealed. A misdemeanor can be my kicking the lady next to me without my shoe on, with my bare foot.
I wouldn't do that if I were you.
I wouldn't dare.
Only kidding.
But there you have it. That's a misdemeanor,
Absolutely.
folks, if the person is convicted of it. And if the person has a shod foot on, that's assault and battery with a dangerous weapon. Yes, it is. Not just a knife or a gun, a shod foot, and most of the assault and batteries with dangerous weapons are with shod foots or a fly swatter or something else, okay? It's 15 years for a felony. And then there are other rules in the law that says in the 10 years before you submit your petition to the Office of the Commissioner of Probation to get the thing sealed, you can't be convicted of even a driving violation for which your fine was greater than $50. So you have many people, and there's this third category of people being hurt by the system, those people who were convicted, and they don't have identity entanglement. They were convicted, they served time, they've come out, and now they need a job and they need housing and they can't get it. This is a crucial time when they come out. And it is a wonderful thing that Sheriff Cabral knows about that and is taking action to do something about it. And even the Department of Correction is turning around these days and is got a reentry initiative with a good person in charge. So there's a lot good coming along. But the problem is that these records for people who did offend, did convict, last a long time, sometimes 25 years after they did the particular thing. These sealing laws have to be changed in our view. I'm happy to say that Representative Byron Rushing, sitting right here, has filed a bill to make major changes in the conviction sealing laws so that 15-year wait for a felony would be 7 years. And the 10-year wait for the misdemeanor would be 3 years. Bearing in mind not only that most people leave the life of crime that they had at some point, but the science of it, and it was mentioned a number of places in the white paper, and we have to bring this before the legislature so that they don't get scared and don't get intimidated into thinking that they're not being tough enough on crime. You're being tough on crime if you don't have recidivism. And the best way not to have recidivism is to help these people when they get out and let them, if they then don't offend within a reasonable amount of time, they're probably not going to offend. That's what the science shows. The sealing laws don't reflect the science that crucial first couple of years after people get out of imprisonment, that's the time they're most likely to recidivate, and if they don't do it then, they're not likely to do it at all. We need sealing laws which reflect the science of this, and besides, make it possible for literally thousands of people who've turned their lives around to get jobs and housing. I hope we get...
Well said.
Let me ask if we could just take a moment to thank all of our panelists for setting the table. We're now going to really turn also to you in the audience as well to share with us. Senator Barrios has a commitment he's got to get to, but could we just take a moment to thank them for really helping us to sort of dissect a very complicated issue here. And now, you are people who've been very, very actively engaged in this issue, have some tremendous concerns about what's going on here. And we want to open the floor for some questions, and I'm also going to be tossing them out from time to time. I was looking for my good friend Haywood. Where is he? I saw him here earlier. There. Haywood, just a quick word. As you hear all of this, is there one thing in particular that stands out for you?
Oh, I think that, the whole panel is... It's a very good idea because we do need to revisit, CORI and how it is and how it could be to make our community safe. And when Tony was talking about what I'm talking about is the importance of providing training and some education for people while they are incarcerated, not just on a county level but on a state level, because if a person has a job and we have some housing for them, that's a big step in reducing the fear factor in our community. And I think that the next step would be to, go out into the community and educate the community about this particular event, and so they can begin to understand that this is a community-wide effort, and it just shouldn't be left up to our elected officials or to our corrections official or to the courts to decide what direction and what can be for people who have reclaimed their lives.
Thank you, Em. Yes?
Wow, I wasn't quite sure why I was here.
Oh, Mike's. Speaking to the mic.
Good morning. I wasn't quite sure why I was here this morning. I brought my friend Frank, who's got a program called Choice Theory, and he was very excited about this, but I wasn't quite sure why I would be excited. But after listening to this panel, I'm amazed that I think the opportunity that lies in front of you all to make some pretty amazing changes. And I think it starts with Andrea, where she said we've got to work on the human error factor in the data. And one of the ways of removing the human error factor is starting with something solid like a fingerprint basis and get the humans out of the input and use the computers to communicate with one another and get the humans in the knowledge working business, and that's taking this database that seems to be something that people don't embrace and are afraid of and use to, sort of use as a power base between one another, between these different groups, and turn it into something people can get really excited about. And fingerprinting, I think, is the beginning, and there's lots of really cool technologies that database could really be combed and cleaned and really empowered with things like, everyone has a cellular phone today. You take a photograph of, the driver's license. You take a photograph of the person who's committed the crime. And then when you see when they're checking into one of our frequent, establishments, one of our jails, and they've got frequent flyer cards, so to speak, of, a dozen driver's licenses, we can sort of see that and figure out which is the real one. And so anyways, I can see that I think the idea is shattering this belief that this database is sort of like the evil thing and getting excited about making it this knowledge base and starting to get people to have fun, not be afraid of it when it's in a flat text, but make it come to life.
Representative Rushing?
Thank you, and I want to thank the panel, and I want to thank the Foundation for doing all of this and supporting all of this good work. Deep in Elise's introductory PowerPoint was one question, and the question was, are workplaces, schools, programs, housing safer? That was in the PowerPoint. Right. And I would really like us to spend some time considering this question, and that is the question, what has CORI done to make Massachusetts safer? I mean, what has or to be more specific, what has making available all of this information to the non-law enforcement population, what has it done to make Massachusetts safer? We can reform CORI and do many of the things that have been said this morning, but the question for me is, do we have the evidence that it matters, that CORI matters, that we should have CORI?
How do you measure a negative? I'm not sure how you measure a negative. I understand your point completely. I'm not sure how you measure a negative. So if it's measured by the numbers of people who would have inappropriately been allowed to work in schools or drive buses or enter public housing, how do you measure that? And inherent in that, on the one hand, I'm sort of saying, I'm not sure we can measure it. On the other hand, I'm saying I completely get what you're saying, because if you can't measure the success of it, then how do you know that it's working? And how do you know that the detriment doesn't outweigh what you say the benefit is?
That's right. Or put another, do we need all these other people to have this information? Is it sufficient to make sure that the information is as accurate and as complete for the law enforcement to maintain the levels of safety that we want to have? And I don't think you can do this anecdotally. You see, I mean, I think that you see, we in the United, because we are shifting our understanding of innocence in the United States, and we have always worked under the assumption in the United States from the adoption of the Bill of Rights that sure you could find more people who are committing crimes if you went into everybody's house systematically, just went and sent people into everybody's house and walked down all the streets in the city and went in and searched everybody's house, you would be able to find criminals that you would not otherwise be able to find, but it is unconstitutional to do that. Right?
I agree totally with the concept that was just brought forward in terms of doing research. And I'd like to piggyback onto that and say, what harm is it doing? And the harm I see, I think the use of CORI is actually increasing the danger of crimes being committed, because the assumption is that if you do not have a criminal record, you're not a dangerous person. And if you look at all of the really dramatic cases where people have harmed children by teachers, by Boy Scout leaders, by priests, none of those individuals had CORI. And so many individuals are protecting themselves from legal suits by saying, well, we checked. But they also need to check, is that person dangerous? And you can find that information other than CORI, by references and things of that nature, which people are neglecting because they're saying this person doesn't have CORI, so we can hire them, and I think that's a danger of public safety.
Can we just see someone in the audience back here, and then I want to ask Councilor Turner.
Thank you. I find this all fascinating. My major concern with what you're saying, and I understand all of it, the legal law enforcement impact versus the social impact. My concern is the racial impact. I'm a career counselor, and I had a gentleman come in to me who had an extensive CORI background. He happened to be white. He knew full well he would have no problem getting a job. The bottom line is, an employer, as it is now, has the right to say, I want this person versus that person. Forget the CORI. And the odds are pretty good they're going to accept the white person. The odds are also pretty good that if they are going to do a CORI check, they were more likely to do it for a black or a minority person. Okay? And I know that's slightly off topic, but I think it's something that we really have to address, because the gentleman ahead who was talking about the people who had convictions but they hadn't done anything beforehand. Their CORIs were clean. I don't know the percentage of sexual predators who are minority versus non-minority, okay, but I would tend to think it is skewed on the non-minority side. Thank you.
Anyone want to touch on this issue of the racial impact?
Well, I can just tell you that we have a little database at our CORI project at Mass Law Reform Institute where we record any call we've gotten from a person with CORI. and analyzed what the problem is. The main problem that CORI's presented for them is that they can't get a job, and the second problem is that they can't get into public housing, the two things they both most need not to recidivate. What we have found just in terms of that data that the woman was talking about is that 52% of the people we've helped or tried to help are women, not men, and that 65% of them are members of minority groups.
Councilor Turner, then I have a question from Councilor Murphy, who I see in the back there.
Yeah, I want to touch on the issue of how the CORI information is used once it's obtained by a person outside the criminal justice system. About 3 years ago, a group of us, including the Director of Goodwill, decided that it was time to meet with the Director of the Chamber of Commerce because we felt that the business community needed to begin to do more work on educating its members and getting a dialogue going between those who were willing to hire people with records and those who weren't. We had about an hour's meeting, and at the end of the meeting, Mr. Guzzi said that it was an interesting question, but it was one that his members really, he didn't believe would be interested in exploring. And that he would get back to us if at some time in the future they were interested in looking at the question of CORI. I haven't seen any indication over the last 3 years that the leadership in the business community is any more concerned with dealing with this issue among its own members than Mr. Guzzi indicated back in 2001, 2002. So the question is, do you see any indication that there is a sincere interest, not just rhetoric, but people, leadership in the business community actually doing things to educate its members and work on these issues within the business community? And if you don't see it, what do you think we need to do as the public to begin to convince businesses that they have a responsibility to engage in this issue just as we are?
I think that actually for business, where the goal is to make money, it's always going to be benefit versus detriment. If you think you want this information because it will save you some sort of civil liability or provide cover for civil liability if something happens, you're going to have to prove to us that you deserve the information. I don't deal a lot with necessarily private industry. Where I don't see a significant interest in educating people about how to use CORI, but I'm not sure what to attribute that to. It could be because people don't even know that they don't understand it. They look at it, and some of them, I think that they understand it. Where I see more of an interest is in finding employers who are willing to hire people regardless of CORI, and that's what we ended up doing in the Sheriff's Department. We are now seeking out employers as part of this Common Ground Institute program, which is literally a 15-week school for people that involves Ben Thompson's Strive program, but also on the back end, a number of employers already committed to giving people jobs, because I think this issue is amazingly complex. People have legitimate concerns almost at every single level that need to be addressed. In the meantime, people don't have jobs. So what you need to do are find employers who say, I don't care about any of that, I'm willing to hire people anyway. And you can structure the job in a way that benefits the person. You can structure a probationary period. You can structure making sure with the person who's taking the job that they agree to continue to participate in the reentry programs that they've hooked in with since they've left. I think the real way to go is, while we're simultaneously reforming CORI, is to engender interest, whether it's tax credits or just plain old compassion and willingness to do the right thing, engender interest on the part of the business community to hire people in spite of the fact that they have CORI. And that's the direction we've been going, because we just don't have time to wait.
Thank you. I'd like to go to Councilor Murphy for just a second. You did offer an order within the City Council on this issue of CORI hiring for the city. Any thoughts you have on this question of how we can encourage employers and agencies?
Reverend, first of all, thank you. The panel was outstanding, and I think you covered just about every aspect of this, in a lot of ways, nightmare of how the system works right now. There are literally people, I think, who have committed an offense who are trapped by that one offense, that there are literally people out there that, it's been one strike and they're out. So the need is to very quickly come together. And I think you've outlined your panel tremendously, the need over several fronts to look at this issue and to make meaningful reform. We do have a council order. There are 18,000 employees of the city of Boston, and one of the points that was brought up over and over again, and that we're seeing as a problem, is who has access, and are they really trained to read and understand what they're reading? Sometimes there's a proclivity, and not all the time, among law enforcement at an arrest point to pile on and to put 8 or 9 or 10 or 12 charges on. But all of that arises out of one incident, and there's really only one salient point that somebody should have been charged with, but because of the overzealousness maybe of someone to say, well, we want to get this person for whatever happened in the incident, let's charge them with 15 things. And then you have somebody who's not fully equipped as a law enforcement professional, so the sheriff's point about maybe having one set of data for law enforcement and another set for non-law enforcement. But that person has to be equipped to look down and say, hey, wait a minute, there's 15 things here, and if you look at a CORI reform on a CORI sheet on a person, that can be daunting, or oh my God, look at this person, there's 15 things right here, and it's all one incident. So what we're doing is I've been having discussions with Mayor Menino and his administration at one level as chairman of public safety, but at another level working with Councilor Turner. We are going to hold public hearings on this whole aspect. We'll obviously be inviting Barry to come down and participate in those, as well as maybe some of the other panel members, because I think you really covered this thing very, very well, and it's on the front burner at City Hall as to how we can make certain that, number one, we do protect. It's our obligation to protect. But number two, we don't sentence people who have, done something wrong, offended, and then, paid for that offense to continue to run in the cycle where they can never come out of it. And we need to address that, and I think we'll work together to do that. And I know Sandy Enriquez from BHA has her hand up over there, so I thank you all.
Who takes Senator Wilkerson, and then...
I do, and I want to apologize to folks who may be sitting here thinking that why the elected officials hogging the mic. Part of it for us is that, and many people don't know, we talk about CORI, kind of who does it. It's a matter of state law, state and federal law, and it's so rare we get a chance to even hear from the public and talk to them about what the challenges are that we have to deal with. And so I want to offer this. I have several pieces of legislation that we've been trying to get through. One has to do with expungement of juvenile records for juveniles that are non-adjudicated delinquent, and we can't even get that legislation supported. Second, one of the members, I think it was Barry, mentioned that the legislation directing them to come up with a plan and a process to kind of clean up this mess was based on recommendation, actually based on an amendment that I filed in the budget 3 years ago, and we've been fighting ever since then trying to make this happen. We talked about bad information. What we haven't talked about is, in my opinion, one of the very easy things we could do is to expand the process of cross-checking information, which, by the way, this administration has been fighting against tooth and nail for reasons I don't quite understand. What we're saying is use more than 2 or 3 fields, matching Social Security numbers with work history, with dates of birth, with former addresses, to check, because John Smith, surprise, surprise, is a very common name. The people that we hear from who are entangled are Janice Brown, Mary Smith. And it happens, and there's absolutely no excuse for us to be fighting against cleaning this up, given the ramifications for what a CORI means when you really have one, never mind a bad CORI when you don't deserve one, and it's life-altering because it could take a decade to clean it up. And you're right, it's solely the responsibility of the individual. Finally, I would say this, because I'm back on where Representative Rushing it said, and I would raise it again. We have to deal with this reality of the fact that when we started this years ago, it was for law enforcement. Very good idea, good concept. I would certainly even agree that there are some crimes that people commit and are convicted for which ought to preclude them from working in some places. What we have done and what we have now is a burgeoning, exploding permanently unemployable group of people who we then challenge to go out and be productive in their lives. And this is the insanity of this process. And let me tell you, it's black, it's white, it's Latino, it's brown, and this is about a culture where drug abuse has gone rampant, and that those people are the ones who have CORI. So we can't talk yesterday about an epidemic in substance abuse across the Commonwealth and then not acknowledge that what that means is that we have more than majority of percentages of black and Latino males and the class age groups from 18 to 25 who in this current climate can never be employed legally other than in black market. That's the insanity, and if we don't deal with it, that is not anything that's going to make us safer, because the only way they're going to survive is to engage in the same kind of activity, because they have to live somewhere, and they have to eat, and they can't get legal employment. And we need to reevaluate the rationale of how we started it, because we never envisioned 3/4 of our male population being in it. And that's what we have. That's what we have. And I want help. I know people want to be safe. People talk about our communities. We're tougher on crime than any, but we want them to have ramifications and punishment for the real criminals. And then at some point they're finished, and we have to then send them out to deliver a productive life, which means housing and a job. Mm-hmm. So that's the conversation that I think that we should be having, because this one is wonderful, but it is all being conducted by rational thinking people with very rational ideas and attitudes, and that is not what's happening out there. It's not rational. Human Services, Executive Office of Human Services, very different from the Sheriff's Office, where you have the kind of freedom to do what you're saying. By law, our Executive Office of Human Services can't do that. They wiped out our entire body of substance abuse counselors and peer counselors that were the best in the country because they had their own experience that they brought to this.
We can see the senator is definitely passionate about this, and rightly so. Speaking of housing, I'm going to ask if the director of the Boston Housing Authority would speak. And I also want to take one more from a non-official response. Do we have someone else? Yes, all right. We're going to take one more. We're getting close to our time here. We promised to get you out by 10:30, but we've got some great discussion. Let's start with
Thank
Director.
you. Thank you for the panel and for this morning. I'd like to ask first a question before my comments. How many people in this room are landlords? Are you a government? No, I got them too. No. How many of you are landlords who have government subsidy tied to your housing? Not that you just take a Section 8 voucher holder, but that actually you run a project-based Section 8 development, you're a management company, et cetera. Not a lot of people. Okay. As we talk about changing and looking at the CORI issues as it affects housing, and housing authorities have been in this statute for a very long time, but also subsidized housing providers also can get that information. I just want people to be mindful. We're always trying to balance the greater good, individual rights, etc. And it's a difficult one. But also on the federal level, the kind of legislation that you're talking about with HHS is happening on the federal level as well. So while I've got in my housing authority a state portfolio and a federal portfolio, I've got to be mindful of what the feds are leaning on me to do as well. And the same kinds of restrictions, the same kinds of if you ever dealt methamphetamine, ever, you can never get into public housing. It's those kinds of things at the federal level, so no matter what you do at the state level, I still have this other umbrella that I have to be responsible for. I would also like to say the hope that my access issue is that you would bring housing providers to this discussion much more than you have, because we struggle, a number of us, with, we're doing a program with Strive as well. We're doing lots of job training. We do have a very strict CORI process and applicant screening and tenant selection. However, we do ask people When Barbara talks about caring, we ask, what are the mitigating circumstances? Tell me. Give us documents. If you've got counselors, if you've been sober for a number of years, bring all that information forward. Let's talk about that. There are very few people at the Housing Authority who have access to CORI, can ask for CORI information, get it, make a determination after looking at it, and then provide a thumbs up or a thumbs down or a question mark or we need more information to people who are actually interviewing applicants for both Section 8 and for our conventional program. Those records are kept a particular way. They are then destroyed so that they're not traveling along with information for everybody else to see. So it's very prescribed. But I think it's important to know the sum total of what housing providers need to provide, why we ask for the information. And yes, it's very litigious, and I have to tell you that I had and we have lots of anecdotal stories, but in reality, I had a gentleman who was arrested for 88 counts of child molestation. And he served his time, and he got out, and left his wife and his child behind at the development while he did time. Family then applied for and got a transfer to a different neighborhood. Well, the information from that development, swirled around, traveled with him to the other development, and all of a sudden I have elected officials as well as residents clamoring for his head on a platter. Common, greater good, individual rights, what do I do? It didn't happen on BHA property, can I evict? The thing happened 20-some years ago. When do we say is enough? But I do have to be responsible to think, will he reoffend? Hasn't in 24 years, but it's such a heinous crime, people wonder about it. And those are all the things that we churn over day after day after day. And I just want people to be mindful of that, particularly service providers who go, ooh, that bad old housing authority won't let my client in. You got to work with us and figure out what's the case, what's the strongest case, how to build a set of facts that really mitigate so that when the feds come and look at my files, they go, you should evict that person. You shouldn't let them in. We're going to audit all of what you do because you screwed up on that one. And that's the reality of what comes from top down as well. Thank you.
I'm going to take one person here in the back. I think we also had a gentleman who was an expert on fingerprints. We're going to finish it with those two if we could.
Good morning. I'm not an elected official, but I work for government, but I feel I'm more community-oriented than anything else. And I want to tell a story about law enforcement. A couple of years ago, the Mass Black Legislative Caucus held a community forum regarding the MBTA police. And I think there's a clear distinction between responsible law enforcement and irresponsible law enforcement. We had a number of young people of color that were coming through Forest Hills MBTA station, after school, robust, really excited. At the end of the day, they were having fun. The MBTA police decided that these kids were rowdy, need to be arrested. They arrested them for no apparent reason. Immediately, these young people got a CORI. These are young people who are in middle school and high school. In about 15 to 20 years, when they go look for a job, they're not going to find one. Never mind 15 to 20 years for summer employment, they may not find one. So the question of responsibility that I ask of this panel and everybody in this room is, when do we hold law enforcement accountable for the kind of charges that they place on people irresponsibly in a way that inherently affects someone's future? The ability to be able to live and survive in this country is critically important. And I think as we're looking at this question of CORI, not only do we look at it as adults who are providing for young people and families, but we also need to look at it from the juvenile perspective. Senator Wilkerson, when she talked about her expungement bill, is very important because these young people, in order for these young people not to have a CORI, there had to be special negotiations that went on between the MBTA police and the CORI in order to get their records sealed. This is ridiculous. And I think we need to really understand the magnitude of the problem in as much as we're talking about young people that are 10, 11, and 12 years old. So I'm very concerned about how we're looking at this issue in its totality relative to what the real basic ability for one to be able to live and survive in this country and in our community affords them the opportunity to be able to have a good quality life.
Can I ask, we hold that just for 1 second? We've got one last comment here, and then I'm going to ask the panel to respond to both that question of expunging and also this comment.
Good morning. I'm Ed Mills, and I have had the unique opportunity to fingerprint over 100,000 people in the last 20 years. I think the CORI is very complex, but fingerprinting is very simple. We do have down at the FBI Information Center in Clarksburg, West Virginia, a database of over 600 million sets of fingerprints that can be utilized. This database, I just want to regress just a second, and the name of the computer that is called Sherlock. This database should be utilized through the CORI system of Massachusetts. Now, I fingerprint people for the U.S. Post Office and people from all the financial district in Boston. It's a requirement through the Security Exchange Commission and the National Association of Security Dealers. I'm sure there's probably a few people in the room that I probably have fingerprinted. But I get calls from people who are going to the state of New Jersey for the bar exam, nurses, truck drivers. Massachusetts literally does not fingerprint for any reason whatsoever other than criminal. You know, they should really step forward. I think we rank either 49th or 50th in the United States. We should step forward and create a database and utilize our database connected to the AFIS at Clarksburg, West Virginia with the FBI. I think it would be a great thing for the state of Massachusetts, because in the CORI law, we just background checks for the people in the state of Massachusetts. When you do a set of fingerprints, send it to Clarksburg. It gives you information of any criminal act throughout the whole United States. And to answer one of your questions on when people are arrested and they're acquitted, if you took a set of fingerprints and put it, if they're acquitted, you take a set of fingerprints, you put it back in the database, and it stipulates that they're acquitted, the record would come out to the FBI report that they've been acquitted. Thank you.
This has been an amazing discussion, lots of energy, and lots more that we could deal with. We're just trying to be sensitive to our commitment to get you out by 10:30. Our panelists will be remaining afterwards for a few minutes. Some have to run, but some will be here. I just want to reiterate that we've obviously raised many more questions that need to be addressed. We've listed here before the public's right to know and the rights of individuals, but I think what we all agree on is that it's very much in the community's best interest to reintegrate as many ex-offenders as possible so that they become assets, not liabilities to themselves, to their families, and indeed our entire Commonwealth. How do we best do that in a way that is also safe? These are the things that we're continuing to wrestle with. We're going to need everyone's help here, and as one person has said, educating friends and neighbors. For me, this really becomes, I think, all the more critical as we've just read the newspapers today, and the Worthington family is filing a suit against the employer of the accused. The question is this going to ignite another round of fear that obscures a much larger and devastating issue for a number of people, or do we, as a Commonwealth, and hopefully as a nation, become more rational, more understanding of what's really at stake here? I want to thank you for your time. Have a great day, and we appreciate your participation. Thank you.
Thank you. Thank you. My name is Richard Ward. I'm a program officer at the Foundation and head of the Community Safety Initiative. I want to thank you all for coming today, and our panelists, and also Reverend Hammond for moderating the discussion. I also want to thank you for coming out, and a few of the people who were involved in this work, the staff of CJI, Len Ingo, Cheryl, and Elise Clausen, and also Jennifer Vorse from the Boston Foundation. But thank you all very much for coming, and have a pleasant day. Thank you.